Welcome to online study of Limitation Act 1963. You know, Limitation Act restricts the time during which a suit is to be instituted. Why it is called Limitation Act? Because it limits the period during which or after which a suit is not to be entertained by the court. If as per the prescribed period of limitation. All you know, Section 3 says, bar of limitation. Section 3, every suit instituted, appeal, preferred, application made after the prescribed period of limitation is to be dismissed, whether limitation has been taken as a defense or not. So, we have already discussed when a suit is instituted, the date on which it was presented to the proper officer of the court, that date will be taken into account. That date will be the date of institution of the suit. Similarly, in a proper suit, when the application is filed to permit a person to sue as a pauper or an indigent person, that date will be the date of the institution of the suit. When an application or writ petition is to be filed before the honorable court, when that is made, when the application is presented to the proper officer of the court, in the case of counterclaim or setup, both setup and counterclaim are to be treated as separate suit. And when the day on which the setup was first pleaded or the counterclaim was pleaded, that date will be taken into account to compute the limitation or to consider whether the suit is that counterclaim or setup is in time or is not barred by the time of limitation. So, what it says, subject to the provisions contained in Section 4 to 24. Section 4 to 24 excludes certain period from the while computing the period of limitation. Limitation and prescribed period of limitation are two different things. Limitation means the period of limitation as mentioned in the schedule of the Act. Prescribed period of limitation means the period of limitation computed according to the provisions of the Limitation Act. Section 3 says, subject to the provisions of Section 4 to 24, both sections inclusive, whenever a suit is filed, suit is instituted, and appeal is preferred, or application is made after the prescribed period of limitation, then that is to be dismissed by the court. The duty of the court that to dismiss once that is not within the prescribed period of limitation. So, subject to provisions of 4 to 24. So, you should know what are the provisions in Section 4 to 24. Section 4 to 24 excludes certain period while computing the period of limitation. First, Section 4 says, if the last day of limitation, if the limitation expires on a day on which the court is closed, then that suit, that application or that appeal will be filed on the day when the court reopens. Section 4 says, expiry of prescribed period when court is closed. What it says? Where the prescribed period of any suit, appeal or application expires on a day when the court is closed, the suit, appeal or application may be instituted, preferred or made. Three verbs are used: instituted, preferred and made. So for a suit is concerned, proper verb is instituted, appeal is preferred and application made on the date when the court reopens. So, court is closed, even if any part of the normal working hour of the court is closed, that will be treated as the date on which the court is closed for the entire day. What this says? Explanation provided to Section 4 provides that a court shall be deemed to be closed on any day within the meaning of this section, that is within the meaning of Section 4, if during any part of its normal working hours it is closed on that day. You see, during this COVID period, this pandemic period, COVID pandemic period, court is not functioning for the entire day. So it is for a particular that is in the normal working hour. It is not the court is not functioning. If any part of the court is closed, and that day is the last day of limitation for filing, for instituting a suit, or for preferring an appeal, or making an application, then the same can be made that suit will be instituted on the day when the court reopens. Section 5. Now, extends of prescribed period in certain cases. You should understand. Prescribed period, that is to be computed according to the provisions of the Limitation Act. Under which provisions? That is from 4 to 24. So that's why Section 5 says extension of period of limitation in certain cases. Not in all cases, Section 5 is applicable. You should bear in mind, Section 5 is applicable only for appeal and application, not for suit, not for filing application for execution of decree under Order 21 of the Civil Procedure Code. What Section 5 says? An appeal or any application. You go to the language of the section. An appeal or any application other than application under any of the provision of Order 21 of the Civil Procedure Code, that is execution of a decree, may be admitted by court after the prescribed period if the appellant, in case of appeal, or the applicant satisfies the court. What satisfies? That he has sufficient cause, very, very important, that he has sufficient cause for not preferring the appeal or making the application within such period. That means only in case of appeal or application, other than that application is other than application for execution of decree, that can be admitted by the court after the expiry of the prescribed period of limitation if the applicant or the appellant satisfies the court that he has sufficient cause for not preferring the appeal or making the application within the prescribed period. Within such period means within the period of limitation as provided in the schedule of the Act. Then what is sufficient cause? That has not been mentioned. Only appellant or the applicant will satisfy the court that he could not file and he has sufficient cause for not filing, not preferring, not filing that appeal or making that application within the prescribed period of. If the court is satisfied, then the same can be admitted. How many days can be admitted? That is not there. So here, so that is each and every case, the facts and circumstances of each case is to be taken into account or to be considered separately by the court. The contention of the appellant. There is sufficient cause for the applicant or the appellant for not preferring the not filing the appeal petition or the application within the prescribed period of limitation. The court may admit it. What is sufficient cause? That is illness may be a ground, or other grounds may be there, or wrong advice of that is a client or the advocate, that will also be taken, that may be treated as sufficient ground. Because the explanation says the fact that the appellant or the applicant was misled by any order, practice, or judgment of the High Court in ascertaining or computing the prescribed period. Because the appellant or the applicant was misled. Not was misled by how? As per the order, practice, or judgment. The appellant or the applicant was misled by the order, practice, or judgment of the High Court. In what? In ascertaining the period of limitation or in computing the prescribed period of limitation may be a sufficient cause within the meaning of this section. In other words, if the appellant or the applicant was misled in computing the period of limitation or in ascertaining the period of limitation as per any order, practice, or judgment of the High Court, and did not file this appeal or application within the prescribed period of limitation, that will be treated that as a sufficient cause for condoning the delay of limitation or admitting the appeal or application. So you should be very careful. Section 5 is not applicable to suit or execution proceeding. It is applicable only to appeal and application other than execution proceeding. So when the appellant satisfies the court, what satisfies? That he has sufficient cause for not filing the appeal within the prescribed period of limitation or not making the application within the prescribed period of limitation, then they may be admitted by the court. What is sufficient cause? That is not mentioned in the Limitation Act. So, facts and circumstances of each case is to be considered separately, is to be considered whether there was sufficient cause or not preferring the appeal, not making the application within the prescribed period of limitation. The explanation makes it clear if the appellant or the applicant was misled. Was misled how? By the judgment, order, or any practice of the High Court in computing the period of limitation or ascertaining the period of limitation, then that will be treated as sufficient cause to condone the delay. This is section 5. So, now let us 6, 7, 8, 9 are very important sections in the this Limitation Act. What section 6 says? Legal disability. What is legal disability? When a question comes, who is a legal disability? Because law treats the only minor, insane, and idiot are legal disabled person. What says section 6 says? As per law treats a person disabled because who is disabled? If he is a minor, if he is insane, or if he is an idiot. You know who is a minor? A person who has not completed 18 years of age, or if a court guardian has been appointed, he has not completed 21 years of age, then he will be treated as a minor. Then insane person, was suffering from insanity. because of some mental defect, that is under development of his mental condition or understanding, he is unable to take decision and to follow day-to-day life. Idiocy is idiocy means a person, you may say a person who is unable to count from 1 to 10. He may be treated as idiot. So, legal disability, what section 6 says, is very, very important. Who is a legal disabled under the Limitation Act? A person that is who is minor, insane, or this idiot is a legal disabled person because he cannot take proper decision. He cannot take proper decision in filing the suit or instituting the suit. Where a person entitled to institute a suit, a person is entitled to institute a suit or make an application for the execution of decree. This is the two cases, only suit and decree, execution petition. Section 6 is applicable. So far as this Section 6 is not applicable to appeal or application. What it says? Where a person entitled to institute a suit or make an application for the execution decree is at the time from which the prescribed period is to be reckoned. These words are very, very important. At the time from which the prescribed period of limitation is to be reckoned. The date from which, the time, not date is not also matter, time. The time from which the prescribed period of limitation is to be reckoned. A person is entitled to suit. A person who is entitled to institute a suit and is a minor or is insane or an idiot when at the time from which this prescribed period is to be reckoned, either a minor, insane or idiot. A person who is entitled to institute a suit is or present an application for execution decree at the time from which the prescribed period of limitation is to be reckoned is minor, insane or idiot, then the suit or application for execution decree may be instituted or filed within the same period after the disability has ceased, as would otherwise have been allowed from the time prescribed therefore in the third column of the schedule. That means the day on which, from which the prescribed period of limitation is to be computed for institution of a suit or for making an application for execution decree, and is on that day the person who is entitled to issue such suit or make such application is minor, insane or idiot, then he can institute suit. He can make such application for execution of decree in the same period of within the same period of limitation which was available to him after that disability ceases. This is section 6.1. So section 6.1 says, if a person is legal disabled, who is a legal disabled person? He is a minor, he is insane or idiot, and he is entitled to institute a suit or make an application for execution decree. At the time when, from which the period of limitation, prescribed period of limitation is to be reckoned, then he is allowed to institute such suit or make such application within the same period which would have been allowed to him, which was allowed to him, which would have got had he not suffered from insanity, had he not a minor or an idiot. Then within the same period he can institute a suit or make an application. Subsection 2 says, where such person is at the time from which the prescribed period is to be reckoned affected by two such disabilities. What are those disabilities? Minority, insanity, idiocy. When such person who is entitled to institute a suit or make an application for execution of decree is affected by two disabilities. at the date from which the period of limits from the time from which the prescribed period of limitation is to be reckoned, he is affected by two disability, or where before his disability has ceased, he is affected by another disability. Suppose a person was minor, after 3 years he became insane, then he affected before cessation of that one disability, he is affected by another disability. Then he may institute the suit or make the application. He may institute the suit or make the application within the same period after both disability ceases. After both disability have ceased, as would otherwise have been allowed from the time so specified. That means after this, both the disability have ceased, he can institute a suit or make an application within the same period of limitation of that which he otherwise would have got had he not suffered from minority or insanity or idiocy. Then subsection 3 says where the disability continues up to the death of that person. A person was legally disabled, that is minor, insane, idiot, then that disability continues up to the death of that person. Then his legal representative may institute the suit or make the application within the same period after the death as you otherwise have been allowed from the time so specified. That means after his death, the legal representative may institute the suit or make an application for execution of the decree as would have been allowed to such person. That is subsection 3. Then subsection 4 says where the legal representative to in subsection 3 is at the date of death of the person whom he represents affected by any such disability. Suppose X died, an insane person died, leaving his minor son. If his legal representative is affected by such disability, then the rule contained in subsection 1 and subsection 2 shall apply. That means if his legal representative, suppose a person was insane. So after his cessation of after his cure for insanity, he can file institute a suit within the same period as which was allowed to him. Suppose during insanity a person died, leaving his only a minor son. So if that person, the legal representative is affected by legal disability as minority, or even minority thereafter insanity, legal disability is affected by true disability, then subsection 1 and subsection 2 will be applicable. That means after cessation of the disability of his legal representative, he can also institute a suit within the same period which otherwise would have been allowed to him had he not suffered from such disability, had he not affected by that disability. Where the legal representatives referred in subsection at the date of the death of the person whom he represents affected by any such disability, the rule contained in subsection 1 and 2 will be applicable. The rule 5 says, where a person under disability dies after the disability ceased, but within the period allowed to him under this section. Suppose a person who was affected by disability dies after the disability is over, but within the period allowed to him under this section. But within the period, suppose 3 years period, 5 years period is allowed to him, he can file. But without filing the suit, without instituting suit, he died. His legality may institute the suit or make the application within the same period after the death, as would otherwise have been available to that person had he not died. That means a person was allowed to file after cessation of disability, he was allowed to institute a suit within say for 3 years. After 1 year, he did not institute suit but died after 1 year. Then his legal representative may institute suit within the rest period of 2 years, which otherwise would have been allowed to him, available to him. For the purpose of the section, who is a minor includes a child in mother's home. This explanation provides minor also a child in mother's home will be treated as a minor. Section 7. By now you are clear what is legal disability. When a period of limitation is to be computed for filing of a instituting a suit when a person was affected by legal disability at the time when the suit is to file. At the time is very, very important. Suppose a person was not insane. When, from the time when the period of limitation is to be computed, but after 1 year became insane, he had not filed the suit. So in such case, this section 6 will not be applicable. Because at the time when from which this period of limitation is to be reckoned, he was affected by legal disability. Section 7 says, disability of one of several persons. Suppose several persons are entitled to institute a suit or make an application for execution of decree. One of them is affected by legal disability. One of them is minor, one of them is insane, or one of them is idiot. If such a discharge in that suit can be given by others, then this legal disability rule will not be applicable. But if that suit, that no discharge can be given in that suit without concurrence of the person who was affected by legal disability, then rule 6 will be applicable. Then after the completion, after cessation of that disability, such a suit or application is to file. Well, now come to provision of section 7. Disability of one of several persons, where one of several persons jointly entitled to institute a suit, jointly they are entitled to institute a suit or make an application for execution of a decree is under any such disability. Suppose 3 persons are jointly entitled to institute a suit. But you should understand the provision of section 7. Suppose 2 or more persons are jointly entitled to issue a suit, or 2 or more persons are jointly entitled to make an application for execution of a decree. One of them is affected by legal disability. What are those legal disability? As I told you earlier, that is section 6, minority, insanity, or idiocy. If the discharge can be given in that suit, so far in that suit, discharge can be given in that suit by the other persons without the concurrence of the person who is affected by legal disability, then time will run, but in such case section 6 will not be applicable. But where no such discharge can be given, where a discharge cannot be given in the suit without concurrence of the person who are affected by the legal disability, then in such case time will not run. This section 7, you should be very careful that when two or more persons are jointly entitled to institute a suit or make an application, and at the time from which the period of limitation is to be reckoned, if at that time one of such person is affected by legal disability, and discharge can be given in that suit, in such case time will run. Then section 6, you will not get the benefit. In such case, the benefit of section 6 will not be given to the person who was affected with legal disability. But when such discharge cannot be given in that suit without the concurrence of the person who was affected with legal disability, then the time will not run. Then the time will not run till the disability of that person has ceased. Explanation 1 says, this section applies to discharge from every kind of liability. This section applies. Discharge means every kind of liability, including the liability in respect of any movable property. So you should bear in mind, discharge may be all types of suits, including immovable property. Explanation 2 says, a karta of a joint family can give discharge of the liability. In such case, time will run. Suppose 3 persons are there, one of against the karta and other members. The karta can give discharge in that suit. So in such case, time will run. What expansion 2 says? For the purpose of this section, the manager of a Hindu undivided family governed by Nitakhar law, manager of a Hindu undivided family governed by Nitakhar law shall be deemed to be capable of giving discharge without the concurrence of the other members. Suppose a suit, a one karta, a manager of a Hindu undivided family, and other members of that family are jointly entitled to institute a suit. Or money can make an application for execution or decree. One of the members is affected with legal disability, and in such case time will run, because as per the explanation 2, the manager of the Hindu undivided, this Mitakhar family governed under Mitakhar law, the karta can give discharge of the liability in that suit. Against 6, 7, 8. 8 is a very important provision. Special exception. Special exception. Nothing in section 6 or in section 7 applies to suits to enforce right of preemption. So now you should bear in mind, you should remember this legal disability principle as provided in section 6 and 7 of the Limitation Act are not applicable to suit for preemption. What is preemption suit? A preferential right of purchase of immovable property when that is to be transferred. This is called right of preemption. Suppose you know, under the Hindu Succession Act, if one of the successor, he wants to alienate his share of property, then the other sharer, co-sharer, has a preferential right to purchase it. So this section 6, 7 are not applicable to a suit for preemption, or shall be deemed to extend for more than 3 years from the cessation of the disability. Again, this is very, very important. And though same period within that is section 6 and 7 allows to make instituting a suit or making up application within the prescribed period of limitation which would have allowed, but again that has been restricted up to 3 years. After cessation of disability, then the maximum period of this limitation which will be extended, that is up to 3 years. That is as per the provision of section 8. This is called special exception. Nothing in section 6 or in section 7 applies to suits to enforce a right of preemption or shall be deemed to extend for more than 3 years from the cessation of the disability or the death of the person affected by thereby, death of the person who was affected with disability, the period of limitation for any suit or application. That means maximum period is available 3 years. It is very important. Then 9 is also important. Continuous running of time. This principle, once the time has begun to run, the further disability will not stop the running of time. This is section 9. Once the time has begun to run after cessation of disability, then for affection, then if that person is affected with another disability, legal disability, then the time will not stop to run. This is very important. What he said, where once time has begun to run, once the time has begun to run, no subsequent disability or inability to institute a suit or application stops it. Very important. Suppose a person was suffering from insanity. After cessation of insanity, he is allowed to file a suit within the prescribed period of time, maximum of 3 years. That is there. Suppose for 1 year or for 30 days, he did not remain silent. And thereafter, again he suffered from insanity. So in such case, the time will not stop to run. So section 9 says, once the time has begun to run, after cessation of one person's disability, then then if he is affected with further disability, will not stop the time to run. Provided that where letters of administration to the estate of a creditor have been granted to his debtor. What is letters of administration? In case of will, if a person is not, executor is appointed by the person testator who has made the will, the court may appoint a person administrator. So where the letters of administrator to the estate means land of a creditor have been granted to his debtor. When that letters of administration has been of a creditor has been granted to a debtor, the running of the period of limitation for suit to recover the debt shall be suspended while the administration continues. This is an exception. What is this? Is continuous running of time. So once the time has begun to run, after the cessation of disability, the further disability or inability of that person will not stop the running of the time. Section 10, you should know, suits against trustee and their representative. This is the only section in the Limitation Act where no limitation is there. Suit can be filed at any time. What is that? To follow the trust property, to get for the income of the trust property. So there is no limitation. What it says, notwithstanding anything contained in the foregoing provisions of this Act, even not considering the provision of section 3, notwithstanding anything contained in the foregoing provisions of the Act, no suit against a person in whom property has been vested in trust for any specific purpose. That when a property has been vested in the person for specific purpose, or against a legal representative, property has been vested in a trust with a person for specific purpose, or a legal representative, or assigned to whom he is transferred, not being assigned for valuable consideration, for the purpose of valuable consideration for money or transfer, that is something different. No, assigned, it is transferred without consideration. Then, for the purpose of following in his hand such property, for the following the trust property, income of such property, is or their hand such property, or the proceed thereof, or of an account of such, or for account of trust property, or proceed, shall be barred by any length of time. You should remember, there is no limitation for instituting a suit to follow the trust property or against the representative of a trustee for accounts of the trust property or proceeds of the trust property and shall be barred by any length of time that is provided. Explanation. For the purpose of this section, any property comprised in a Hindu, Muslim or Buddhist, religious or charitable endowment, charitable purpose, then shall be deemed to be the property vested in trust. Wherever any property which is given for charitable purpose under Hindu, Muslim or Buddhist religious endowment shall be deemed to be property vested in trust for specific purpose. That will be treated as trust for specific purpose. And the manager of the property, who manages that property, he will be treated as a trustee. Now, section 10, you should remember that no period of limitation is there for instituting a suit to follow the trust property or the income of the trust property or for the accounts of the trust property. And for the purpose of this section 10, even any property which has been given on Hindu endowment for charitable purpose, religious purpose, endowment means religious purpose, endowment means religious purpose, charitable endowment, but the Hindu, Muslim, even Waqf property, Hindu temple property, this Muslim, Buddhist property, monastery property, charitable endowment shall be deemed to be property vested in trust for specific purpose, and the manager of that endowment will be treated as trustee. Let us complete section 11. Suit and contracts entered into outside the territory with this act extend. Suppose a contract is entered outside India, whether this limitation act will be applicable or not. Suits instituted in the territory to which this act extends on contracts entered into any state of Jammu and Kashmir. This is no longer there, Jammu and Kashmir, or in any foreign country shall be subject to the rules limitation contained in this act. It is called law lex fori. That is forum. Even if when a contract is entered outside India and that a suit is filed in respect of that contract in India, then the period of this limitation act will be applicable. What it said? Suit instituted in the territory to which this act extends. If a suit is instituted in a court to which the limitation act is applicable, is extends, or for a contract entered in Jammu and Kashmir or outside India, then shall be subject to the rules of limitation contained in this act. No rules of limitation in force in state of Jammu and Kashmir or in a foreign country shall be a defense to a suit instituted in this state territories on a contract entered into that in that state or in a foreign country, unless the rule has extinguished the contract. Even this load limitation of a foreign country or Jammu and Kashmir will be a defense, unless that limitation extinguishes the contract or the parties were domiciled in that state or in the foreign country during the period prescribed by such rule. This is section. Domiciled means with intention to live there permanently. Parties were domiciled in that state or in foreign country during the period prescribed by a schedule, by such rule. This is up to, we completed up to section 11. In the next class, we will discuss part 3, that is computation of period of limitation. How limitation is to be computed. Thank you.